Yes, we're
Oh,
going to record.
it's already being recorded. Okay. Okay,
Mhm.
thank you. So let's gonna start it. So good morning, ladies and gentlemen, and welcome to the ICN webinar on the Lateral Conduct Working Group. Today we're gonna focus on lessons learned in regulator sectors. It's a very interesting topic that has been there for a while, but I think that every time that we can gather the experience from very different jurisdictions, I think that explains how rich this topic might be in real world concrete cases. I am Victor Oliveira Fernandez, and I'll be your moderator for today's engaging session. And today we are very fortunate to have a panel of esteemed experts from Spain, Georgia, Japan, and Azerbaijan, who will shed light on several aspects of competition and regulation in their respective areas. This webinar, I got to say, represents a key initiative of the ICN, highlighting the necessity of understanding competition issues through real practical scenarios. I think that it, especially when we are talking about this interplay between economic regulation and competition law, it's vital to bridge the gap between theory and the realities we face in the field of competition law in just several sectors. So today's format will involve two rounds of questions for each one of the panelists. And I think that this approach will allow us to dive deep into their experiences from these several jurisdictions. And following these rounds, we will open the floor for questions and answers, providing you with the opportunity to engage directly with our speakers. So let's begin our journey. And first, I would like to present and to invite Mr. Sergio Sinovas, head of the Energy and Industry Unity from the Spanish Competition Authority, and to start us off. And Mrs. Simona, please share with us your experience, the collaboration between the competition director and the market regulators in the sector that you know so well. So thank you for giving us the opportunity to hear you, and the floor is yours.
Thank you, Victor. First of all, I want to appreciate the unilateral conduct co-chairs for organizing this event, this webinar, and for Kaji for organizing and hosting the webinar. Um, First of all, I would like to introduce basically the structure of our institution because it's going to be quite relevant in my further presentation. We have a council made up of two chambers, one chamber dedicated to competition issues and another one for regulated markets. All the cases submitted by the competition directorate are going to be fine or going to be assessed by this competition chamber. But we have another chamber which is the one who's going to cover all the regulated markets. With this structure, we have 5 different directorates, the competition directorate, but also four more directorates, the advocacy, but also the energy, telecom, and transport directorates, which are the former regulators. Now they are going to be part of the institution as a directorate. It's very important for the structure I'm going to explain. And between the different directorates, competition directorate and any other sectorial directorate, we have formal and informal cooperation. We have formal cooperation in with different tools, such as one of the main important ones is the cross reporting, but also we have info sharing and market definition tools. As regards to cross-reporting, it's very important. Every time the specialized chamber, the regulating chamber, is going to solve any conflict in the access of transmission, for example, in energy issues. So every time they're going to solve a conflict in the access of in the transmission or distribution grid, the regulated chamber needs a cross reports from the competition chamber. So the competition directorate is going to make this draft report clearing the transaction, stating that there is no overlap with competition issue. So every time they are dealing with this conflict of access, or for example, there are some sanction proceedings according to the specific regulation, the competition directorate has to assess this infringement, this conflict, and take a look at if there could be any potential antitrust infringement. So for us, it's very important since it's a very relevant source of potential antitrust infringements. Indeed, we have open proceedings after this draft report. We have opened different sanctioning proceedings once we detect a potential infringement with these cross reports. We can detect potential abuse of dominant cases, such as with Enel, when we saw a potential abuse and we find this infringement, but also we can detect potential gun jumpings. Every time a new company acquires or modifies its participation in a regulated market, they have to submit the request, a clearance from the regulated chamber, and that's in this cross report we can detect that maybe this behavior could also represent a potential merger, need to be assessed and cleared by the antitrust or by the competition chamber. So this cross reporting between chambers is a relevant source of potential infringements. Also, we have info sharing between directorates. Every time we see a potential infringement from the specific regulation, or our colleagues detect a potential antitrust infringement, we exchange officially with some documents. We exchange this indicia among us in order to detect and saw if there would be infringements. Also, it's very important for their role. They need to separate, and they need to control and monitor the need of the separate markets. Every time a company is involved in a regulated market and a liberalized market, they need to share and split the different branches in the company, and they don't have maybe the right tools to monitor these necessary split among regulated and liberalized sectors. And in many cases, our tips, once we have detect that maybe more tools could be enhanced in order to enhance this separation among the businesses, they follow us and they put it in the regulation. And also, the reports published by the different directorates is a very relevant tool for us to define the markets in our merger cases or in abuse of dominant cases. But also, we have an informal cooperation. The former one was the one included in our law, but also we have informal cooperation, very useful for our investigations. For example, we have set up an horizontal working groups, such as the one made up of different members from all the directorates, touching and addressing topics of common interest for all of us, and also they organize visits to the companies, to markets, and it's very useful to understand the markets. We have also trainings. Our colleagues from the competition directorate train our other colleagues from the specialized directorates, and on the same page, our colleagues from energy, from telecom, they also train us in their markets. This is a very useful tool, this informal cooperation, to understand the current situation of the markets, because in our daily basis, we don't know the current situation, but our colleagues from the energy on telecom sectors are very aware of the latest status in market, and also to know the legal regulation in place. So sometimes it's very specific, very complex, and that's a very relevant tool for us to define the market and to know all the legislation applicable to our cases. So, as you know, we have this formal, but also we have very informal with these joint teams, common teams. That's very useful and very insightful for all of our investigations.
That's very interesting to see how sophisticated your system is in terms of how you connect all these areas. And I think that especially when it comes to topics just as like access and to regulator sectors by third parties, I think that there is of course a very interesting field for cooperation from competition and regulation perspectives. So thank you very much, Sergio. That's a very insightful analysis on your collaborative dynamics at CNMC. So now let's turn our attention to Georgia. And Mr. Hamazi, we are very eager to hear about Georgia, especially because we know that we have some new legislations introduced in 2020. So we would like to hear from you, how does the interaction between your competition and consumer agency is working, especially after the introduction of this regulation. So thank you very much for being here, for taking our time for this. And we know that you have prepared a small presentation for us. Thank you for that as well. So the floor is yours, and we are going to share your presentation with our colleagues.
Thank you, Victor. First of all, I would like to mention that it's my great pleasure to attend on this to this webinar. It's a very good opportunity for us to share our experience and also take some new advantages and new experience from our counterparts. So first of all, I would like to mention that the Parliament of Georgia adopted the amendments in 2020. So basically, there was a large amount of amendments, and one of them was directed to the cooperation between regulators in terms of examination of competition cases. So our main view was to regulate and clarify the issues which was gap before. So first of all, we started to find the main gaps which was before, and the thing was that the legislation did not contain any kind of rules regarding the allocation of power between the Georgian consumer and the competition agency and other regulator. So that's why the new law presented us that and presented and clarified and create new legal basis that legislator provided us a three condition where the competition and consumer agency is responsible to take leading of the case where the subject of violation is committed, and this case is contained in other energy other regulated economy of regulated. So these three condition this condition is contained by the law. The first one is that the alleged violator of law, I mean the law on competition, or one of parts of the concentration is not undertaking in the regulated sector of the economy. The second condition is that the alleged violator of law and the parts of the concentration are the undertakings of various regulated sectors of economy. And the third condition is that the entity allegedly violating of law is the undertaking of regulated sector of the economy, but the subject of dispute has not been carried out in the regulated sectors. So the legislator provides us these three conditions where the competition agency is responsible to take leading of the competition case. Otherwise, we have the obligation to forward the application which is submitted by the party and contains alleged violation of the competition in the regulated sector. We have the obligation to forward it to the another regulator, such as the energy regulator, telecommunication regulator, and National Bank of Georgia. And we clarified during the amendments, we clarified the time limits. For example, we have 5 days in order to forward such complaint to the relevant regulatory authority. Also, if we need to some clarification, legislator provided us 30 days time limit in order to give consultations to each other, competition agency and other regulator, in order to agree this complaint contains the regulated sector, or it contains to take some responsibility from the competition agency. So before this amendments, we did not have kind of such kind of time limits and regulations. After I would like to mention that these amendments gave us some kind of convenience in order to decide this case contains, for example, energy field, or this case should be examined by the competition agency. After this, one of the main issue of this amendment was that the other regulators gave the obligation to use the particular articles from the law on competition. So before the amendments, they did not have any obligation to use the law on competition because they examined the competition cases by their bylaws and by their legislation. But after this regulation, after these amendments, another regulatory bodies have the obligation to use the particular articles, such as abuse of dominance position, such as cartel restriction of the agreements, to use such articles. And I think this is more convenient in order to create unilateral practice between the regulatory bodies and the competition agency. Also, I would like to mention that we after the amendments, we another party submitted to us the first case, and it was the dispute was committed in the energy sector, and we had consultation with the energy regulator, and we decided together that this case should be examined by the energy regulator, because the criteria was not met, which is defined by the law, by the new amendments. So this is our key stone of our this is keystone of our new amendments. So after this, regarding the new amendments, I would like to also mention that the another regulators created the bylaws, which is more or less similar the bylaws of competition agency, and but they have some clarification with specification of concrete field, and this is our opinion. This is quite convenient in order to create the unilateral practice between the regulatory bodies. So this is what I wanted to say to you that we clarified concrete special rules in order to decide this case should be examined by the competition agency or as another regulator, because in practice, in some cases there was some kind of special, it is necessary some kind of special knowledge, for example, energy sector, and we did not have such kind of special knowledge. And that's why we proposed such kind of amendments. And after this, it is very convenient for us to allocate such kind of cases.
Thank you. Thank you very much, Mrs. Amazi. It's very interesting to see how things is going to work, and you are assessing the first cases after the introduction of the legislation. So very insightful presentation. If you don't mind, we could share with all the members of this meeting after the meeting ends. But we will reach you for that. But thank you very much for a very interesting presentation.
You're welcome, and I will explain this first ever case after the amendments. So I will explain the kind of structure of the case and the final decision of the regulator.
Okay. So continue on. Let's shift our focus to Japan. Mrs. Kagami, we are very curious about your Japanese approach, especially in the digital sector. So could you explain a little bit to us what are the roles of the several regulators and sector regulators in addressing unilateral practice, especially in the digital sector? I see that you have also a presentation. Thank you for that. So the floor is yours. Thank you.
Thank you, Victor, and thank you very much for having me today. I'd like to discuss the regulators and sectoral regulations in Japan. My name is Aruto Kagami. Nice to meet you, everybody. If you could see on the screen, there are various regulators regulating various industries, and Japan Fair Trade Commission is the primary competition regulator, and the Anti-Monopoly Act is the primary legislation to regulate competition. The JFTC also has jurisdiction over Subcontract Act, which is like a regulation that similar to abuse of dominance. So if a certain business operator has certain size and if it subcontracts services to a smaller player, then Subcontract Act regulates competition in between those business operators of different sizes. Also, there are consumer affairs agency which regulates like misleading advertisement and also digital platforms. But we also have Ministry of Economy, Trade and Industry, and METI also has regulation over under the legislation called improvement of transparency and fairness of platforms. So it's not mentioned here, but it is a legislation that requires certain digital platformers like Amazon and Google to disclose certain things such as the reasoning for ranking in their search engines, for example. So this legislation sort of requires the digital platformers to disclose certain things for consumers to understand how the platforms operate. And under this legislation, METI is monitoring the digital platformers and digital platformers are obliged to publicize sort of the the result of the monitoring, and whether there was any improvements for their disclosure or their interaction with the consumers. Those will be publicized at the end of the monitorship every year. So that's how METI is monitoring the digital platformers under this legislation. Digital platformers are sort of required to improve their dealings with the consumers through those disclosure obligations. This legislation doesn't have like ex ante conduct regulations, but it sort of expects digital platformers to improve themselves. So through the monitoring shifts that I just explained. So this regulation is called a co-regulation type of legislation because it sort of allows METI to monitor the digital platformers, but digital platformers are also expected to take voluntary measures to improve their sort of disclosure to consumers, for example. So we will discuss that later on. But there are other agencies like Electricity and Gas Market Surveillance Commission, Financial Services Agency, or Ministry of Health and Labor and Welfare. They all have different legislations, and they are regulating, respective industries.
Thank you.
So if you focus on the digital sector, the Japanese government decided to create a sort of headquarters for the digital market competition. So this is called HDMC. And this organization is cross-sectoral, and they gathered all the experts in academia and employees from various agencies to sort of come together and address the recent issues in the digital markets in the wake of those growing concerns posed by the digital platformers. And since the issues run across ministries and agencies, this organization is cross-sectoral, as I mentioned, and it has employees from METI, MIC, or JFTC, or academia and external lawyers. This headquarters for digital market competition has been very active in conducting various studies, and also published reports on mobile ecosystem, which had a profound impact on how the JFTC, for example, sort of prioritize its sort of investigation priorities. And also the report had an impact on the Japanese government to sort of consider a new legislation much similar to DMA in Europe, which will is expected to introduce some ex ante conduct legislation, like prohibition of self-preferencing by digital platformers, for example. So it is yet to be seen. We haven't seen the draft of the legislation, but we understand the government is currently considering such legislation following the sort of the studies and the reports published by the digital market competition headquarters. So I'll stop there.
Thank you very much, Mrs. Kami. It's very interesting to see how you managed to put in place a cross-sectional approach for this topic, because, as you said, it's very difficult to put digital activities into boxes of sectoral regulatory approaches. So that's really very interesting and to hear from your experience. So now let's explore the situation in Azerbaijan with Mrs. Jamalov. So Mrs. Jamalov, we're keen to understand the current state of competition policy and regulatory mechanisms in Azerbaijan. Are there anticipated reforms, and if are, what factors have prompted the need for these changes?
Okay, good day to everyone. Thank you for inviting me, and I wish you success for all participants of this event. And I hope that the sharing of the practice will be useful for everyone. As you mentioned, my presentation will be about the new competition code of the Republic of Azerbaijan. Can you see my presentation? Great. So, new competition code of the Republic of Azerbaijan. The new competition code has adopted by the Republic of Azerbaijan on 8th of December 2023, and this code actually will become effective on starting from the 1st July of 2024. But once the competition code enters into force, previous laws, which currently we're following these rules, these laws, antitrust activities, law on unfair competition, and law on nature monopolies will be considered as revoked. And the competition code, a new competition code, is comprised of 12 chapters and 84 articles, which actually will regulate competition, antitrust, monopolies, rights and duties of market participants, competition authority, sanction and penalties, and detailed rules about vertical and horizontal agreements which restricting competition, unfair competition, economic concentration of market, and others. So these are the structure of the new competition code, which actually start with a general provision and then continue with duties and rights of market subjects or economic subjects in the field of competition, and competition authority, agreement restricting competition, dominant position in the market and relatively high market power, also unfair competition, economic concentration, compliance with competition legislation by state bodies, and state regulation in the field of nature monopoly, measure of the state control over compliance with competition legislation, consideration of cases on violation of competition legislation, and liability for violation of competition legislation. So these are the necessities, the reasons why we're actually why we actually needed to develop a new competition code. First is coming from the strategic roadmap of the national economy perspective of the Azerbaijan Republic, which is approved by the Azerbaijan government by 2016. And second important reason is again the additional measure related to increasing the business environment in the Republic of Azerbaijan and further improving the position of our country in international rankings, which also approved by the President of the Republic of Azerbaijan 2017. And third reason was national priority of sustainable growing competitive economy of Azerbaijan 2030, national priorities for socio-economic development, which approved by the 2021. So these are government's programs for the developing of the economy, and also to be ready for the new economic and social challenges to ensure sustainable and competitive economic development, to apply modern regulatory methods. So these are the main reasons why we actually need to develop a new competition code. And then my next question was about the differences in new competition code with the previous one. And I tried to combine the important of the, there are actually lots of differences, but I try to give some important points of those differences, and I gather like advantage of new competition code. If we look at it from general point of view, these are the accurate definition of the market boundaries, and transferring informal relations to the legal level in the field of control of economic subjects, expanding the scope of application of competition, implementation of the goal and result-based competition system, demanding payment of damage from the market subject who obtain illegal income as a result of violation of the competition by the market subjects, and determining the obligation of officials of the competition authority to observe the principle of conflict of interest. If we look at from the agreement side, the recognition of agreements without negative consequences, and the regulation of modern trade models, prohibition of obligation not to compete, evaluation of the practice of adapting the behavior to the actions of another economic entity as a case that violates competition, and regulation of agreements in the field of the public procurement, are referring to the criterion of changes in market share as evidence of the agreements, and determination of the obligation to refrain from cartel agreements, and defining a wider list of the horizontal and vertical agreements. If we look at the from dominant position, determining the classified dominant position criteria, application of price-based abuse criteria, recognition of the principle of protection of public interest, alignment of the price discrimination criterion with the result-based competition principle, regulation of the dominant positions in digital markets, it's called network effect, and adaptation of property abuse to current practices and modern economy. And I would like to add one important differences about the dominant position. In the new code, competition code, the dominant position is considered to be as if the economic entity has a market share of 50% or more. But in the previous laws, which actually we are currently following those rules, the 35% or other or more indicate that the economic entity has dominant position in the economy. Also, in new competition code, we have also 2 or more economic subjects together, which those actions are directly or indirectly join the relevant market. When the combined market share of 2 or 3 economic entities exceeds 50% of the market share, or when the combined market share of 4 or 5 economic entities exceeds 70% of the market share. So in those cases, they are called they are actually considered as a dominant position. If we look at the national monopolies perspectives, defining the concept of a person whose activity is not regulated by the competition law but offers monopolized products and services, inclusion of additional national monopoly area, applicability of agreements and provisions related to the dominant position to subject of state monopolies and national monopolies, control of the competition body overall fixed assets and investment of national monopoly subjects, and determination of separate inspection rules to be applied to national monopoly subjects, inclusion of market monitoring and inspections as additional control measures, application of special financial sanctions for national monopoly subjects. In this actually new competition codes, the financial sanctions indicated as a 0.2% of the total turnover of the national monopoly. And also national monopoly subject must submit the financial reports on the results of economic activity to the competition body in the form and manner approved by the Cabinet of Ministers of the Republic of Azerbaijan by the 20th of the following months at the end of the quarter. And in the end of my slide, I tried to put one example from the telecom sector, Telecom and Baku Telecom Communication, which actually the result of the investigations, a case was filed against Telecom LLC and Baku Telecom Communication on the science of manipulation of prices in order to gain an additional advantage in the market. Also, as a service, we also received applications from private internet providers regarding those enterprises. Those private internet providers note that the increase in tariffs had a negative impact on their activities. And according to the adopted decision, Astelcom LLC and Baku Telephone Communication were instructed to adapt the service tariffs determined by the internal orders to the requirements of the laws of Republic of Azerbaijan on telecommunication and regulated prices, as well as decision to the Tariff Council, and a fine was imposed on the aforementioned companies in the form of the financial sanction. Thank you for your attention. It was my presentation.
Thank you. Thank you very much. It was very insightful to hear from you, Mrs. Jamalov. And now we are gonna go back to the top and make another round of questions with our esteemed panelists. So moving back to Mrs. Sergio, could you share with us a little bit, Mrs. Sergio, some antitrust case with a close cooperation between the Competition Directorate and the markets regulators? You have set a very interesting institutional design, which seemed to me very sophisticated. So I'm eager to hear how does it works in practice. So could you share a little bit with that for us?
Yes, thank you, Victor, for your question. Indeed, this structure means that sometimes we have close cooperation and means that sometimes we have antitrust cases when with the help, with a very useful help from our colleagues from other directorates. As the case in Audax, Audax is an electric and gas supplier group. And in last 2 years ago, 3 years ago, we were receiving a lot of complaints from individuals stating that they were demanding, they were suffering different misleading practices by their different suppliers, electricity suppliers, and they were changing their current supplier of gas and electricity with some misleading behaviors. We check with our colleagues from the Energy Directorate, and they agree in the sense that they had already the same complaints from the market. So we began to assess the potential infringement we could have in these practices. First, we rule out a sectorial regulation. So our colleague says, well, we don't have nothing to do. So if there is something, it could be antitrust issue. And in our in the Spanish Competition Act, there is also some Article 3, which enables us to find an unfair competition practice that may constitute an infringement and a competition infringement if it affects the public interest. So in this case, apparently, we had an unfair competition practice that was affecting the public interest because there was a great number of complaints from this behavior. Our colleagues of the Energy Directorate, they submit a report, including all the complaints received by them to date. And with this report and all the complaints submitted by different companies and even a trade consumer association to us, to the Competition Directorate, we opened proceedings. The parties were these all different and several companies belonging to the same group, Audax Group, which is a domestic supply of electricity and gas. And as I mentioned before, these different companies belonging to the Audax Group, they were incurring in misleading and deceitful practices. For example, they submitted a fake it, but it was all the offers, they were made by phone with call centers, and they were first they had access to the customer database belonging to a very big electricity supplier. And once they had all the information from the customers, they began calling them and presenting themselves as workers from the current supplier they offer them fake it tariffs renewals or updates or discounts on their tariffs, or even they ask for a mandatory change in the supplier, trying to deceive and mislead the customers. And they were very successful. But thanks to our colleagues from the Energy Directorate, we were able to track all these changes. We were able to see that with these practices, Audas had increased their market share dramatically, very sharply in months. We also see the great number of customers obtained with these practices because with the help of our colleagues, and also very useful for the trust case was an assessment made by the by the Energy Directorate, which estimate the early termination rates with these customers. In Spain, when you change your gas or electricity supplier, you have 2 weeks, 15 days to stop the change. So we assess that in relation to the rest of the suppliers, the customers obtained by Audax with these practices, around 80%, they stopped the change. So we could deduce from all this information that there was an illegal and misleading behavior between before this increase sharp in the new customers obtained by this group. Of course, all this assessment was possible because our colleagues were able to have access to the data, to customer data, when you can see the prices, the current supplier, and all the details. Is very confidential. They are not able to disclose this information, but they put it in an aggregated way so that we could include it in our case. So we were able to find with almost 10 million euros this group for this misleading conduct, and it was a very successful case of a joint joint investigation together with our colleagues from the Energy Directorate. Currently, it is under appeal before our Court of Appeal, but we cross fingers and we'll see if can be successful for the near future. Thank you.
Thank you, Mr. Sergio. It's a very interesting case, and we can see how this your sophisticated system actually and generate some benefits for individual cases. So thank you for the explanation. So now let's go back to Mrs. Ramazzi. Could you say a few words for us about some ongoing cases since the new amendments of the law? You have already mentioned it very briefly in your first part of your presentation, but could you give us a more color on that?
Thank you, Victor. So first of all, I would like to mention about the first case after the amendments. It was our first practical experience after the new amendments and new rules. So one of hydropower plant named as Pshawela hydropower plant submitted to the competition agency the application regarding the alleged violation of abuse of the dominant position. The application was against one of water supplier, which is under the regulation and supervision of the energy regulator. So we saw that the subject of violation was committed in energy sector. Also, the both parties of the respondent and the applicant also was involved in the energy sector because they are under the supervision of energy regulator. So we according to our new rules, we are obliged to forward this application to the energy regulator and ask to them opinion whether this application is examined by competition agency or energy regulator, because as I mentioned before, according to new amendments, we have 3 exceptional conditions where the competition agency is responsible to take leading in competition case in the energy sector, in the regulated economic sector, and I mentioned these 3 conditions, and we decided that during the application period, during the admission period, there was not given these 3 exceptional condition. That's why we forwarded this application to the energy regulator and asked them opinion. So they responded us, and we also proposed them that, in our opinion, this application should be examined by the energy regulator. That's because I mentioned before the explanations, because both parties were under supervision of the energy regulator, and the violation was committed in the energy field. So the energy regulator responded us, and they accepted us, and they started investigation upon our request. So as for the details of this case, was that one of water supplier refused this water supply to the one of hydropower plant because they had kind of agreement on each other, and water supplier raised the tariff, also the water supply tariff, and finally they refused to supply the water. So the Energy Commission started the investigation, and according also to new rules, we were able just to involve in this case as a consultants, and we had some kind of consultation meetings with the Energy Commission, and we exchange our views, and we also provide to them our legal opinion regarding this case. So and after this, the Energy Commission decided that there was not any kind of violation of abuse of dominance, because they calculated the tariffs. Also, they calculated the profit margin of this hydropower plant, and they decided that the hydropower plant can also continue the operating without this water supplier. So, and they could not find any kind of violation, but now we create some kind of practice according to the new rules, that we forwarded one competition case, and this case was examined by competition rules. So the energy regulator used kind of similar practice, examination practice, as the competition agency used before. So this was first case. As for the ongoing cases, from the starting of this year, we gave 3 complaints, which the details was the violation was committed in at other regulatory field. So 2 cases were contained the field of regulation of National Bank of Georgia, and 1 case contained the field of regulation by the energy regulator. We forwarded these 3 applications to the relevant regulators, and they accepted to us, to our opinion, that they should be leading bodies in order to examine these cases, because the whole content of this case contains the relevant regulatory economic field. So this is our ongoing cases and ongoing practice, and we have also right now possibility to involve to examination of these cases, just to issue the legal opinion to the relevant regulatory bodies.
Thank you very much, Mrs. Hormozzi. It's very interesting. So we are running a little bit out of our schedule. So I would like to ask for our esteemed panelists to try to be brief and in the next rounds of questions, so we can cover all our questions. And now we're gonna move back to Japan and to Mrs. Kagami. So we have the first round kind of assessed the institutional design and the models of the legislations. And could you explain a little bit to us how this institutional design has resulted in practical solutions in for the digital sector? And I see that you're going to talk about a little bit about your so insightful studies. So the floor is yours, Mrs. Kagami.
Thank you, Victor. In Japan, the several agencies and JFTC in particular has led many sort of initiatives to conduct studies and surveys into the digital sector. On the screen, I've laid out some of the examples of these initiatives, and many of them really address private monopolization or unilateral conduct type of concerns in the digital sector. Well, some of them, like algorithms and AI, do address horizontal issues as well. But the primary concern is the growing power of the digital platformers and put their potential to sort of abuse their sort of dominance or engaging unilateral conduct to sort of drive away competition or inflict harm onto consumers. So in 2019, METI, Ministry of Economy, Trade and Industry, and JFTC, and Ministry of Internal Affairs and Communications got together and proposed options for rulemaking in the wake of platform business. This included, promoting more fairness and transparency of trade practices by the platformers. That led to the legislation that I described in the earlier part of the presentation, the Act on the Improvement of Transparency and Fairness of the Digital Platformers, which required certain disclosure obligations upon platformers and allowed METI to continue monitoring the ship of the digital platformers. And then the JFTC also conducted many surveys and organized study groups that resulted in various reports that mentioned in this screen, on the screen, like algorithms or competition policy for data markets, and also survey on the trade practices in cloud services sector, and also more recently survey on mobile OS. And the HDMC, this is the headquarters for the digital market competition that I described or mentioned in the first part of the presentation, conducted many surveys and finally assembled a report on competition evaluation regarding the mobile ecosystem. So this report had a profound impact on the sort of the legislative initiatives by the Japanese government, including the ex-ante regulation that I mentioned before, but also set priorities for the agencies like JTC to engage, conducting investigations into potential conduct by the digital platformers. This final report by the HDMC included, issues like anti-steering provisions by the digital platformers, or the fact that they require certain payment system or application software or application store app stores to distribute apps on the mobiles. Because in Japan, mobile market is very highly concentrated by two operators, Apple and Google, and that's why this report has led to investigation by the JFTC into several conducts by those digital platformers. One of them included the anti-steering provisions that were mentioned in the final report as well. So the JFTC was able to secure a commitment from Apple to sort of allow link out to external websites to allow users to purchase digital contents from external links. But this is just one example. But the HDMC's final report had impact on the JFTC's investigation that resulted in many commitments from digital platformers in the recent years. So thank you.
Thank you very much, Ms. Kim. It's very interesting. Is those stories, at least some of them, in English, available in English? Yes. Oh, that's very interesting.
Yes, sure. Yeah, if you go to the JFTC's website, for example, you can find the English version of the surveys and studies and reports.
Oh, that's very nice to hear. Yes, I have came across once with the AI and competition policy report, which is very, very interesting and rich. So thank you very much for this. And now going back to Azerbaijan, please, Mrs. Jamalov, could you explain a little bit to us where the lessons have been learned from some past experiences, and how does the new competition code differ from the existing legislation? As you talked, we know that you are contemplating some novel legislation. So what is your view on that?
Thank you for the question. I think regarding on this question in my presentation, I tried to respond the advantages of the new competition code from the general point of view, agreements and dominant position perspectives, and also nature monopolies perspective. But I also would like to mention that I actually anticipate that there will be more cases after the adoption of new competition code, because there are specific provisions for nature monopolies and the business entities for not to violate competition rules, for example, such as submitting financial statements and others. So again, we anticipate that after the adopting the new competition code, will be more cases, because we are accepting lots of problems about the nature monopolies in this field. Also, I would like to mention that we have also a case with Azerbaijan Railways, which actually going on, and the result of the investigation, the case was filed against the Azerbaijan Railways in accordance with the antitrust laws on the lease of wagons, railway transportation, as well as the application of tariffs and discounts. And this is actually one of the biggest case, which again going on currently after the Astelcom case. So we have differences in terms of the, if we compare the new competition code with the previous one, we have very important differences with the dominant position, with the natural monopolies case, in terms of the financial sanction, and also have biggest differences with the government regulation on those, on nature monopolies, on others. So that's my response.
Thank you very much, Mr.
Can I raise one question to Mr.
Yes.
Roshan regarding
Yes,
the
of
new
course,
code?
Mazi.
So I would like to just ask you, Mr. Roshan, during the drafting of your new code, could you use some EU regulations or EU directives, or?
So there's a problem with the.
Did you use some EU
Uh-huh.
regulations or EU directives during the drafting of new code of competition?
I'm sorry. The question is about international experience or what? I didn't again catch the question.
Did you use kind of EU regulations or EU directives during the drafting
EU
of
regulation.
the new code? Yes.
You mean
yes.
EU? Yeah, we have
regulation.
we have lots of references on the OECD regulation, and also let me specifically mention we have checked the national law Germany, on Turkey, and US, and Czech Republic, Lithuania, Austria, Russian Federation, and also Kazakhstan competition law, and also we have we actually give the references about the vertical block exemption regulation from the European Union, and also merger regulation from the European Union competition law. So we have lots of international experience on this new.
Thank you very much.
Welcome, Mirko.
Thank you.
Thank you again, Mr. Zumilov. As we are a little bit ahead of our scheduled time, I'd like to briefly pause and check in with our audience if there are any questions from the audience that you would like to address to our panelists directly. We see that your engagement is valuable, and we would welcome your inquiries and thoughts. So I think that Marlon would like to ask something. I think that you can just open your microphone or your camera, and let's make it very informal and very simple.
Good afternoon, panel members. Thank you for this opportunity. My name is Marlon. I work at the Competition Commission of South Africa. I'd just like to ask a question, or just to gather whether the panel members could provide some insight. I note that they have spoken about the cooperations between, for example, the energy regulators. There, I think was a common example, and the authority during certain cases where there could have been potential concurrent jurisdiction. But either in their own jurisdictions or in their experience, if they know of any other places and how things possibly were dealt with, where there was possible conflicts. So, for example, I'm trying not to be too specific, but if you take energy, for example, in a country like ours, we have a regulator there. And I'm sure during their development, for example, say if you're talking about prices of, say, gas, where we virtually have a non-existent gas market. But in their considerations of setting prices in the gas market, they would have determined their methodologies and come up with a potential price. And a sector regulator would have a different mandate, in as much as it could include competition principles, but we have our own competition commission who has also its own mandate and different sections of the act. So, for example, now the sector regulator in the energy could have determined and passed laws to say this is the regulated price. The motivations behind it, for example, could have been we need to try and stimulate, for example, maybe investments in this industry so that we can grow this industry. That, for example, in a developing economy could have meant that prices, for example, could be excessive or a lot higher than would otherwise been the case, or at least the way our act is written. So in terms of our act, the Competition Act, we would have had specific benchmarks that have been set out to help determine what's an excessive price. And yes, we do have memorandum of understanding, but and what has also happened is that the respondents in our matter have taken the matter that we investigated, for example, to court to say that, for example, do we have the right to investigate this matter, for example, as an excessive pricing when the prices have been, when clearly have a sector regulator who one would think would be the primary, I would just use that in inverted commas, and then say we don't have jurisdiction. Our courts have come back and confirmed again that we do also still have jurisdiction, at least in terms of, for example, excessive pricing. Our act says that the act defines that the act gives us the benchmarks and the factors need to be considered. And obviously now going forward, this potentially could be, I won't say a sticky point, but if you wanted to apply, if one has a sector regulator who's trying to achieve some developmental outcomes, so the price that he would have chosen in this instance would have been a maximum price. And obviously industry participants are adhering to his laws, not exceeding that, but then falling foul of our laws. So there is obviously some conflict there. I'm not sure whether you guys have some experience along those lines or any experience from your years of working in other jurisdictions, etc. Thank you.
Thank you very much, Marlon. It's very nice to hear your question and to know that South Africa Competition Authority is also joining with us. I don't know if I see that Sergio would like to jump in and to provide some answer.
Yes, indeed. There was a very interesting remark and question posed by Mr. Dasarath, since indeed within the competition, the CMC, we have several and different conflicts. Every time there is a complaint submitted by gas or energy distributor, first thing we will see if there is an overlap. If there could be sectorial infringement and also antitrust infringement. And if it is the case, we have to, it's one of the reasons to have an integrated model. We set together and we decide who is best allocated to deal with this infringement. Of course, we are not going to look for the same infringement. We are not going to overlap in our effort to stop the practice. So, but this is one of the main reasons to have this system, because it's very, every time we see a potential overlap, it's very useful to give a call, to meet our colleagues and decide if this behavior is because of regulation or is because a lack of regulation. Sometimes it's when it's clear that the regulation is the main the reason for this potential infringement in antitrust, we don't have anything to say. But if this gray area, because this practice is maybe due to some regulation, but our colleague says no, nothing to do with our instructions. In these cases, great cases, we go ahead with help because many cases the regulated companies the first appeal is no. Wait a second, this is a regulated market. You have nothing to do with this sector because everything is regulated. I'm following what your colleagues from the Energy Directorate are telling me, and sometimes it's wrong. Sometimes they appeal, but we found a way to go ahead But it's true. In many cases, with these potential overlaps, well, of course, we don't try not to fall in the non bis in idem principle, but it's very useful to really understand the extent of the regulation, trying to prevent these conflict cases from happening. But indeed, we have several cases of potential abuse of dominant position, and the dominant is a regulated company within a group, and within this group, it could be abuse of dominant, but also mislead or wrong doing by a regulated company. And sometimes it's not easy to find the best allocated. Sometimes we discuss, sometimes there is a disagreement, but at the end we try to find the better solution for try to stop this practice. But yes, this is very frequent and yeah, very good. A very great point you raised.
Thank you. So do we have any more questions from our audience? So as I said, regardless, the discussion is very rich, full, and it's very interesting to see all these different perspectives. I'm afraid that we have to come to an end of the session because of the time. We're a little bit ahead of our initial schedule. So as we draw this webinar to a close, I really want to extend my how grateful Kaji is for hosting the sessions, and I'd like to thank our esteemed panelists, Mr. Sergio, Mr. Ramazi, Mrs. Kagami, Mrs. Jamalov. I think that your expertise and the ideas you have shared today have shed very important lights on how complex this interplay between competition policy and regulatory regulation sectors and can be in real world scenarios. So I also want to thank our audience for the engagement. And we are open to eventually receive more questions, and we can, of course, send them to our panelists. So if you like to write for us, we would be happy to make this bridge. So once again, thank you for your contributions, and our ICN group continues. So we're going to have quite more seminars. So I think that's very important. We continue to foster these important discussions and collaborations in the future. So have a great day. Thank you very much, everyone, and goodbye. So good morning for everyone.
Thank you, Victor.
Thank you.
For your moderation.
Thank you very much. Thank you very much.
Bye.
Goodbye. Have a nice day.
Nice day.